Hey guys, welcome to Agile Wealth Weekly. We have a special guest here today to embrace us with his knowledge. So very excited about that. I'm John Oliver.
I'm Steve Livingway.
And I'm Nick Bohr.
So our guest today is going to talk to us about how we can protect and control our assets, as well as our just in control of the choices that we make. So RJ is, well, you know what, RJ Cronkhite, why don't you just tell us a little bit about yourself and the firm you work with, and a little bit about your background.
Sure, John. I'm very happy to be here. Again, my name is RJ Cronkhite. I'm a partner at the law firm of Dinsmore and Shohl. We're actually a national law firm, among the largest 200 firms in the nation. We're in 13 states. We've got 30 offices, so we're a national practice with a national footprint. I myself am based out of the Troy and Ann Arbor offices in Michigan, and I do have a national practice, but my practice is mostly focused on Michigan and with Michigan law.
Excellent, excellent. So we did a survey. We sent it out to our clients, and we asked them, what area would they like to get a little bit more information about. And so this is a little bit of a teaser. We're going to do, hopefully in person, but it might be more of a formal webinar, but soon here in the next several weeks, depending on what's going on. We're going to try to, do an in-person workshop with RJ. If not, it'll be some sort of a webinar where we will talk a little bit more in depth about some of the things that he does and he can do for us when it comes to estate planning. But in the meantime, everyone picked number 3 and number 1. So number 3 was just the general ways that I can protect and control my estate and my legacy through powers of attorney, wills, trusts. So let's just take it from the top, RJ. I know we got a lot to cover. Would you say, so, and we're just going to start right from the start here, get right into it. But what's a financial power of attorney, RJ?
Sure. Let me, if you don't mind, John, let me
back up
a little bit.
Sure.
I want to talk generally about the concept of trust and estates and estate planning and what that means and what are why do we have trusts and estates in the first place?
Excellent.
And I think if you look at the phrase estate planning, it gives you a insight into why we have it. It's about planning, and so much about the law is about planning. Whether it's a contract or an employment agreement or an estate plan, what we're trying to do is we're trying to plan our affairs in as precise a way as possible so that we can have a measure of control, a measure of certainty, a measure of comfort with what will happen to us, what will happen to our estate. And if you start with that concept in mind, I think it helps inform our discussion today, which is it's a trust and estates generally as an umbrella term. And within that field, you have multiple pillars of trust and estates. You think of the will, you think of the trust. Those are classic pillars of trust and estate that help you plan and control your estate and protect it, of course. What I'm going to be talking about today specifically is another pillar, one that's not discussed as much traditionally as wills and trusts, but is becoming increasingly discussed as we continue to live longer and face different challenges in the estate planning realm. So I'm going to talk about the durable financial power of attorney that you mentioned. I'm going to talk about what's called a living will, also known as a medical power of attorney. And I'm also going to talk about a patient advocate designation, which interlocks with a living will to ensure that you have a measure of control over your health in the event you are incapacitated or disabled and can't make healthcare decisions by yourself. So back to your question, John, a durable financial power of attorney. So I think it's a little history lesson. Back in the day, before we had powers of attorney, what would happen in the event that someone suffered a debilitating medical condition such that they couldn't go to the bank, or they were hospitalized and couldn't write checks? Back in the day, you would have to get what was called a conservatorship or a guardianship over the financial assets and estate of the incapacitated individual. And the problem with that is it's extremely costly, it's slow, sometimes it's contested, it involves initiating court proceedings, which for anyone who's been through court proceedings before, they're both slow, especially nowadays in COVID, and they're costly. The financial power of attorney was designed to circumvent that delay and that cost through court proceedings. Very similar to why we have wills, is to avoid probate, right? If you've got a will, you can avoid the court process in terms of distribution of your estate assets. You've got the will, those are the directions, that's the planning, it can be executed. The same with the financial durable power of attorney. It designates somebody who's authorized as your agent to make financial decisions and have financial control over your assets. That's what a durable power of attorney is.
Excellent. And that can happen, right? I mean, life goes on and things happen. I mean, we can find ourselves in the position where we can't make those decisions. So we definitely need to protect against that.
It's increasingly common. I mean, I think there's long been a need, even if it's been niche, for durable power of attorneys. But nowadays, as we live longer, it's becoming more and more critical. That's why I call it a pillar in estate planning. Everyone really should have these, really. And I'm looking at it from the perspective of two individuals. It's one, the person whose assets the person's planning for. So me, like, I want a financial durable, power of attorney so that I can assign an agent in the event something happens to me. But we all know people, right, who they don't plan as much as we want them to. So if you're a son or a daughter of an aging parent, you probably want to have that conversation with them, to make sure that if something happens to them, they're not just floundering like a ship out there without a sail. And it's going to save a lot of headache when something, catastrophic perhaps happens, God forbid. The last thing you want is red tape and having to go to court simply to gain control and be able to direct the assets.
Exactly.
I think people might be wondering, who determines whether you're incapacitated? So when this would kick in, is that determined by your doctors, the court? Who determines that you're disabled or incapacitated and this would kick in and your designee would now take over your financial decisions?
That's a fantastic question. A traditional fighting point in powers of attorney is whether the person's in fact disabled or incapacitated. It's like a contract in the sense that it depends what the power of attorney says. So you can create a mechanism or a protocol for determining who's incapacitated or who's disabled. I mean, the baseline rule is if there is a clearly demonstrated incapacity to make independent financial decisions for oneself. The mechanism that I favor is to actually have a practitioner, a physician who certifies the state of disability or incapacitation. And that way, it's in black and white writing in the durable power of attorney. It can be contested, but it's much more difficult to do. And you have an expert who's making what should be an expert decision. And hopefully, to the extent someone disagrees with it, like a family member, well, the expert's usually going to trump, especially if it's been clearly spelled out in the financial power of attorney, that is what we're going to use to determine this question.
Excellent.
And so RJ, you'd mentioned a couple things. So other than the traditional things that it can help one control, what are some of the other areas that it'll actually allow control over when it comes to if you did get into that state where you actually needed someone to act on your basis? So what other things other than the classic things that we normally associate with it that you can control?
Yeah, it's an interesting question. It really can be over virtually any asset, and I say virtually without pun intended.
Yeah.
Something I'm thinking of that you really don't see that often is electronic assets in financial power of attorney. I think it's because it's a relatively new type of asset. You know, we didn't have to worry about emails 40 years ago. You know, that is until Al Gore invented the internet. That's a joke. But you know, now with email, you think of emails, how critical emails are to a continuation of a business.
Correct.
Or a person's personal affairs. I mean, it's almost like the mail. Can you imagine if you couldn't access your mail?
Yeah.
So something I always include in my financial powers of attorney, unless the client, for whatever reason, doesn't want it, is control over electronic assets. Social media is another one. But email accounts, both business and personal, I think are a huge one.
Interesting.
So how does I know it's probably wide differentiation, but how does a living will differ from a financial power of attorney?
So a living will, it's a bit of a misnomer. It's not a will. Okay, we call it a living will, but it's really not. What a living will is a document that lets third parties know, particularly healthcare facilities and the courts, if need be, what your wishes are regarding your healthcare in the event that you're not able to make the decisions yourself. So, you know, we're thinking of, again, a situation in which an individual is incapacitated or disabled. We think of, for instance, God forbid, somebody has been in a car accident and they are in a hospital bed and they're in a coma. Mm-hmm. What do we do? The default rule is that they are going to be maintained on artificial life support. What a living will does is it allows the individual, again, to plan and to give directions to the healthcare facilities. And again, the courts, if need be, if there's a fight between siblings or parents or family members generally are the ones who disagree what should happen to the person's healthcare in those situations. The living will, there are instructions.
Okay. I was in that situation twice with both my parents, and luckily my sisters and I agreed both times, but that's one of the reasons my wife and I both got a living will. So you don't really want to put your kids in that situation, trying to make that decision there. It's really emotional, and it was actually a very difficult decision there. You know, when you're there in the emergency room or wherever you're at, and then someone comes out and asks you, what should we do? So I think it's great. I think it's something you can do to really take that burden off your children or your family members by putting that in writing ahead of time.
A fantastic point. I mean, the emotional value of having a living will in place is immense. And it's horrible when you see a disagreement over a healthcare decision, a life-altering healthcare decision, and then they go to court, right? Yeah. And then you have the additional, you know, trauma and costs of a court proceeding, which is not only expensive, but uncertain, right? You don't know what the court's going to do.
Correct.
Which is why it's so nice to have it in writing ahead of time. You know, you take that decision in a way, in a sense, away from the courts and away from your family members. You're basically saying, this is the instruction, just execute, just do it.
Yeah.
You know, it's interesting because that's usually one of the, you know, unfortunately, if you go into ER or something like that, that's one of the first questions that you hear now is do they have a living will or a patient advocate or medical power of attorney?
Yep.
you have something in writing for them. That's usually one of the first things they ask now.
If
What
you
are-
don't, if
Go
you
ahead.
don't have it, you're basically relying on oral statements. It's got to be clear and convincing intentions that are somehow articulated. It can be very, very difficult to do if you don't have it in writing.
Yeah.
Are there some items on these living wills that seem to be missed, or make sure that need to get them into this living will that are often exceptions or anything?
I think there's a couple points that I think bear emphasis. A common question I get asked about living wills, this has to do with the designation of the patient advocate, which we'll talk about in a moment. But a patient advocate is basically the individual that you appoint to implement your living will in the event that you're incapacitated. And a common question I see, and sometimes it's a mistake that's made by the person who's creating the living will, is designating an institution as like a hospital as the party responsible for making the decision. You can't do that in Michigan. It's got to be an adult. It's got to be a person. So that's one thing that I think people need to be aware of when they're creating these living wills. I think another thing is be specific. Be specific. I mean, if you want a do not resuscitate, put it in there. If you don't want if you don't want to allow blood transfusions, spell it out, put it in there. You got to be as specific as possible. Otherwise, it gets too generalized, and you're putting your patient advocate, designee, and the healthcare providers in the same situation that you were in as a default. So you got to spell out if there are specific things you don't want, if there's specific things you do want regarding your healthcare, put them right in the living will.
So a patient advocate, make sure it's somebody, not your church, not the hospital.
Someone you trust. Just like with all these estate planning tools, if it's someone you're putting in control of your estate as a personal representative, if it's a trustee of your trust, if it's a patient advocate designee, if it's someone you're assigning as agent for your financial assets, trust is the critical question. Do you trust this individual to make these decisions?
Is it usually a family member?
Certainly.
Yeah,
Certainly it is.
Do you find that people do they have those discussions prior to say, hey, this is what I'm about to do? Do you have any problems being this advocate for me? Or
the responsible individuals have that conversation. They're the ones planning.
yeah, exactly.
The thing with a patient advocate designation, you can't just unilaterally do it. You just can't say, I choose you. It actually has to be accepted.
Okay.
You have to have the conversation in order for it to be legally effective. And as I said, the responsible individuals, they have those discussions and they do that planning as opposed to just kind of let the chips fall where they may.
Do you think this? Go ahead.
I was just going to make a point real quick. It's interesting that you say that, RJ, that it's got to be accepted, and you definitely should have that conversation because, I know mine personally. When my wife and I did ours, I know that my kids are still minors, and I know that I did not want my mom as successor. In case something happens to my wife, or God forbid we're in a car accident together. I didn't want my mom to have to make any medical decisions on my behalf, just because emotionally, could she be able to do that? So I personally have one of my best friends as successor patient advocate that I've known since I was 7, because I'm like, I don't want my mom to need to worry about this.
Good point.
Happen to my wife.
It takes planning. You gotta give it careful thought.
Yep.
Yeah. Do you think this is something that clients should share with if they have a good relationship with their financial advisor, with some of these conversations?
Absolutely. When you have a professional team, whether it's your attorney, your CPA, your financial planners, I believe in having informed knowledge between all the parties. You don't want a major participant in your professional planning to be in the dark. No surprises, doesn't help you.
100%. So with COVID, has this impacted some of the things that, you know, you're dealing with your clients? How has COVID impacted maybe some of the new, you know, policies, things of that nature? Has it changed anything in your realm, in your industry?
Yeah, so COVID, you know, of course, has presented multiple challenges to virtually every industry, mine included, you know, specific to trusts and estates and to powers of attorney and patient advocate designations, living wills. There are, with those types of documents, heightened signature and witness requirements, because these documents, as part of, you know, planning your life in a sense, and planning your assets and how they're going to be allocated, it's so important that the lawmakers and courts have determined we need extra safeguards when you're creating these documents. Specifically, you know, when it comes to, you know, a living will, you need it not only signed, but you need to have it either witnessed by two individuals, or you needed to have it signed under notary, so that a third party is observing your signature, validating this is actually who you are. COVID has created a huge nightmare with doing these things. Right? How are you going to go to a notary? How are you going to go to the two witnesses when you're in a shelter in place? You know, Michigan's actually one of the few states whose governor passed an executive order that allows for remote execution of these types of documents. And the order actually lays out the procedure by which you can have something notarized by basically audio-visually, like we're doing via Zoom. And in fact, Zoom is a common tool that's used now by notaries in order to remotely execute signatures. I mean, anyone who's done it, you know, knows you actually have to go take the document in front of go to a bank or an office who has who's a notary, and you have to sign it in front of them. So the fact that Michigan has allowed us to kind of use something relatively novel and not permissible in the past to sign these documents, I think is should be taken advantage of. You know,
It'd almost be easier to get this in place now.
Yeah.
No reason to wait, right? You can get it in place now, get it notarized over a virtual call, and get all your documents in place. No reason to wait.
Very good point. Save yourself a trip.
Yeah, save yourself.
Yeah. Is this going to end, RJ? Is this like, you know, executive order until X date, or is this for further notice? Or
it actually is set to expire today.
Whoa.
I have not seen whether it's being renewed. If I were a betting man,
yeah,
I'm guessing there's probably an order going to be entered today, or it may have actually been entered last evening that's renewed this. But inquire because it may, or it's technically sunsetting today.
Interesting. So kind of put all this together, RJ, I mean, is there any kind of final thoughts that you'd like to share before we wrap this up?
Yeah, I to give some specific insight on, financial powers of attorney, something that really needs to be carefully considered that I think is omitted from consideration is, do you want it to be effective now, or do you want it to be effective upon your disability? You see people go in different directions. You have the decision to make that person your agent now. So if they wanted to go to your bank and withdraw money, if they wanted to write checks on your behalf, they could do it now, if that's what you say in the durable power of attorney for your financial matters. Or you can have it what's called springing, which means upon the occurrence of a certain event, typically your disability or incapacitation, you can have the power of attorney go into effect. Think about what you want. I mean, if you don't want someone else to be able to basically control your financial affairs, you don't want to have it effective now. You want to have it spring and become effective upon an occurrence that you define. The pushback to that is you do sometimes see fights over whether the occurrence has occurred, right? So disability or incapacitation, people will say, wait a sec, you are not the power of attorney right now because the event hasn't occurred. My mom's not incapacitated. She's not disabled. So you can't act as her agent. And when you think about the very purpose of having these powers of attorney, which is to expedite, to save costs, to avoid hassle, you nonetheless having a fight over whether the occurrence has occurred, you kind of appreciate that there is some risk in having your powers of attorney as spring. The way that I protect against that, and Steve actually touched on this earlier, is I have in my powers of attorney a specified protocol for determining whether the occurrence has occurred. So if it's incapacitation or disability, I typically have a stipulation that a licensed physician, sometimes two, have to certify it. And once you have that certification, it's binding, it can't be contested, absent some kind of fraud. So you can have it both springing, which I think is typically what people want, but you also have short-circuited potential challenges to whether the agency is effective.
And real quick, would the powers of the advocate change or end if that patient then became, back to everyday normal living?
Oh, absolutely. Yeah, I guess it's an occurrence, really, I should say condition. Once the condition ends, once the person has not, no longer is under that condition, it depends on how it's drafted, but it typically would revert back to the individual granting the power of attorney, assuming it was springing, of course. If you made it effective immediately, it would just be effective. But if it only happened upon incapacity or disability, once that condition's gone, it typically phases out within 30 days. But again, it's up to how you can draft it how you want.
So real quick question, because this is a very common misconception as well, RJ. Whether it's the medical power of attorney or whether it's the financial power of attorney, do those continue if someone passes away, or when do they end?
So I'm thinking for a financial power of attorney for an individual, what happens in that situation is you technically have the assets passed to an estate. So, and in an estate situation, you have a personal representative who is the individual who's typically strictly authorized to deal on behalf of the estate's assets. So in a way, really when the person passes away, a durable power of attorney is no longer effective because typically that person, there's no agency left because there's no individual left. It's the estate that's left. And then you have to go through the personal representative appointment, which is a whole nother discussion, which is one of the other major pillars of estate planning is having the estate document, having the will, having your personal representative chosen, and the personal representative, one of their powers is a financial power of attorney.
And it could be the same person, but it might not for whatever reason. Right.
Yeah, it often is the same.
Right.
Yeah. I think that'd be nice to go through that other pillar one day, RJ. That'd be great.
I'd love
maybe our workshop / maybe webinar would cover the major pillars like we discussed before, and then maybe some things that are just not thought about. But you guys have any other questions, Steve, Nick?
Just one point. I mean, I'm really glad we have this topic today, RJ, because it's amazing how many people, I'm 55, there's so many people my age or even older that really have not thought about any of these things. And I really do believe, not only for your own peace of mind, but it's really something great you can do for your kids, your family, and take care of these things ahead of time. Because I really do believe if they're dealing with a loved one who's incapacitated or whatever's going on, let's not add on all the other stress. Let's have this all worked out ahead of time. So I really think it's something people should take the time to figure out now. There's really not any reason to just put it off.
I agree.
Exactly.
And
so,
it's relatively low cost. I mean, we're not talking about.
It's not difficult.
Yeah, it's not a huge expenditure to take care of this.
So thank you for talking about it today. I think it's really important.
Yeah.
and that's usually, where we step in with our clients, is we try to be that conduit to make sure that they go and talk to their local RJ of the world, and obviously our clients get access to RJ. But if they wanted to seek you out, how can we get a hold of you, RJ, and what's some of your contact information other than what we'll post on this video? We will post your information, but just in general, what's the best way and to get a hold of you?
I like phone calls. My number is 734-558-5809. Email works just as well. And John, I'm sure you'll share that. I don't have to tell my Dinsmore email account, whatever. But ultimately, whatever, it's all about communication. Whatever is easiest for the person communicating, reach out to me whichever way you prefer.
Awesome. And we want to offer that to everyone watching as well, to get access to us. We believe the same thing. We found that a 15-20 minute phone call kind of skips a lot of the messing around and the questions and the curiosities. Just get the 15-20 minute phone call, see if we're a good fit, see if we can provide value to you guys. So we're obviously offering that as well. Our contact information will be there, as well as, please visit our website. You can see it there, agilewealthpartners.com. All this will be in the comments below. And, we also, RJ, it'd be nice to get a piece or two from you that you think is viable on our Facebook page. That's kind of where we really stream a lot of great information for our clients. But I would say we have been lacking on the estate and legal side of things. So I would love to get some input on that from you, RJ. And then also, if you guys reach out to us either on the website, you will see some forms in there. You can request some information. So what we're going to do here in the next few days is we're going to talk to RJ and ask him what he thinks would be a good piece to fulfill any of your interests, questions, or concerns that we can get to you guys. So it's just our no obligation planning tool that we always offer at all these